Texas is so concerned with pregnancy and making sure that as few pregnancies are as terminated as possible, that they put into their laws that the only way that you can have an abortion is that, quote, in the exercise of reasonable medical judgment, the pregnant female has a life-threatening physical condition aggravated by, caused by, arising from a pregnancy that places the female at risk of death, or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. So, you would think that because of the high esteem that the state of Texas is putting on pregnancies, that a condition that would cause somebody to become infertile and as such no longer be able to become pregnant would meet that criteria of being a serious risk of substantial impairment of a major bodily function. Right? Wouldn't you think that that would be the case? That if the doctor is saying that if the patient continues to remain pregnant in the condition that the patient is in, and the patient will be infertile, that this is a substantial impairment of a major bodily function? I mean, if it's permanently infertile, to me, that's a substantial impairment of a major bodily function, especially if you're feeling that pregnancy is so important that it has to be protected at all costs. Well, if you're not being hypocritical at least, but hypocrisy is a conservative prerequisite. So let's continue to see what this ruling says. Texas Health and Safety Code. Only a doctor can exercise reasonable medical judgment to decide whether or not a pregnant woman has a life-threatening physical condition, making an abortion necessary to save her life or to save her from a serious risk of substantial impairment of a major bodily function. If a doctor using her reasonable medical judgment decides that a pregnant woman has such a condition, then the exception applies, and Texas law does not prohibit the abortion. In this case, the pleadings state that Mrs. Cox's doctor, Mrs. Damla Carson, believes Mrs. Cox qualifies for abortion based on the medical necessity exception, but when she sued seeking a court's pre-authorization, Ms. Carson did not assert that Ms. Cox has a life-threatening physical condition, or that in Dr. Carson's reasonable medical judgment, the abortion is necessary because Ms. Cox has the type of condition the exception requires. No one disputes that Mrs. Cox's pregnancy has been extremely complicated. Any parents would be devastated to learn that their unborn child's trisomy diagnosis, 18 diagnosis. Some difficulties in pregnancy, however, even serious ones, do not pose the heightened risks of the mother exception encompasses. The exception requires the doctor to decide whether Ms. Cox's difficulties pose such risks. Dr. Carson asked the court to pre-authorize the abortion, yet she could not, or at least did not, attest to the court that Ms. Cox's condition proposes the risk the exception requires. But she did. It has been stated that her condition poses a threat to her fertility. Despite this, the trial court ruled that a prospective abortion would fall within the medical exception to Texas abortion laws. Based solely on the verified pleading, it issued an order restraining the Attorney General from abortion laws against Dr. Carson and others related to the case. State seeks relief. We note at the outset that we may grant mandamus relief when the trial effectively resolves the merits of the case in a temporary restraining order. The state has also challenged the trial court's jurisdiction, arguing the plaintiffs have not pleaded a claim for relief that the court has the power to decide. The trial court did not rule on the state's plea, as it must at its earliest opportunity. Concluding a trial court without jurisdiction cannot order relief, even temporarily. The trial court declared the abortion laws unenforceable based on the court's opinion that the exception applies. A woman who meets the medical necessity exception need not seek a court order to obtain an abortion under the law. It is a doctor who must decide that a woman is suffering from a life-threatening condition during her pregnancy, raising the necessity for an abortion to save her life to prevent impairment of major bodily function. The law leaves to physicians, not judges, both the discretion and the responsibility to exercise the reasonable medical judgment given the unique facts and circumstances of each patient. Problem with that is that what doctor is going to take the risk of making the determination that they believe that it is a medical necessity for the procedure to take place without the legal guidance, and then risk the punishment of the law if the law comes in and say, well, we think you're wrong. If it's up to the doctor to determine it, then the state should have no ability to come in and challenge the doctor. That's where the law makes no sense. If it's up to the doctor to make that decision according to the state Supreme Court, then there should be no jurisdiction for the state to come in and second guess the doctor. Period. You either have to let the doctor make the decision and have it be that, or you have to then allow allow people to come to court and say, okay, is this abortion okay or not? You can't have it both ways, because if you don't allow the doctor the ability to make that decision without being second guessed by some attorneys or by the attorney general or by the courts, then the doctors are not going to make that decision, because they're not going to risk their lives or their livelihood or imprisonment or fines or their family's livelihood or their jobs or whatever, just because they're not attorneys and they can't determine whether or not their procedures are going to meet the requirements of this poorly written law. So if I'm to read what the Supreme Court is saying, if it's the responsibility of the physicians and not judges, the Supreme Court here is saying that you should not be able to come in and, after the fact, and tell a doctor, hey, you made the wrong decision. But we all know that that's not what the Supreme Court is saying, because, well, that would require the Supreme Court to be giving up its power to then come in and hammer doctors over the head with bang bang Maxwell's silver hammer, and yeet them from their positions because they're activist conservatives who want to act and use their judicial power to prevent women from ending their pregnancies, even if their pregnancies are a risk to their lives or they are a threat to have a severe, permanent physical problem, as worded in the law. How is it worded again in the law? A substantial impairment of a major bodily function. And again, we go back down to the Texas Tribune article that says the lawsuit brought by the Center of Reproductive Rights said that continuing the pregnancy posed a threat to Cox's health and future fertility. The lawsuit said, according to the article, so the Supreme Court is lying, because the lawsuit said that the pregnancy posed a threat to Cox's health and future fertility. And if it's a threat to her future fertility, that means that there is a serious risk of substantial impairment of a major bodily function. So again, we have more. So not only do we have conservative activists on the federal Supreme Court, we have conservative activists on the state Supreme Court as well. And Texas becomes one step closer to becoming Gilead, because through the wording of this law, which doesn't spell out how the people are supposed to make that determination as to what determines or what spells out is a life-threatening physical condition, what is considered to place the female at a risk of death, or what poses a serious risk of substantial impairment of major bodily function. And the court is supposedly, again, leaving it up to the doctors, but then Ken Paxton, after somebody performs Ken Paxton is threatened to say, we're going to come in and we're going to take action. We're going to arrest you if you do this. In complete contradiction to what the Supreme Court has said. Supreme Court, again, says the law leaves to physicians, not judges, the discretion and responsibility to exercise the reasonable judgment. BS. B freaking S. The Republicans in Texas put the power squarely in the hands of the government, of the attorney general, of law enforcement, and the courts. And they took the power away from the patients and the doctors. And no amount of legal jargon, no amount of horrible Supreme Court rulings, no amount of any sort of legalese is going to take that away. This ruling is a bunch of BS. And it forced Kate Cox probably just saw the ruling on the wall, and that's why she left the state earlier to go get the procedure out of the state, because she was like, you know what? I'm not putting my future fertility at any further risk. I'm not going to make myself put myself in any more risk. I want to have a baby later. I want to have more babies with my husband. I want to have another kid. So I'm not going to put myself in future risk. I'm going to go to another state or another country, because offers have come in from Canada, from Colorado, I think, from Kansas. Kansas, for frick's sake. Conservative-ass Kansas, where abortion is protected because the voters said, no, F you, we're not allowing this crap. She got offers to come from various different places. So she left the state. She went to go take care of and handle her business to make sure that she does not have a permanent physical impairment, so that she could continue and try and have a kid with her husband at some point later in the future. Don't give me that BS that it's up to the physician's judgment. No, it's not. That's why the law is worded in the way it is. And that's why Ken Paxton's threatened to sue or threatened to arrest the doctors and took his actions that he did. Because it's not. If it was up to the doctor's discretion to do that, there would be no need for the law. And this is why, again, Texas is one step closer to Gilead. This is why we live in a horrible society where Texas just keeps discriminating against women. This is why I have more on Ken Paxton, and why we're going to continue to have shows like this as we keep encroaching on body autonomy, as we keep encroaching on the rights of individuals to make decisions for themselves and their own bodies, as we keep eliminating the rights on body autonomy, on fertility rights, on reproductive rights. This is a major issue for me, because it can't apply to me. Look, I'll never have to face having an abortion. Never. But I take this issue seriously, because as it's part of my Jewish upbringing. If you want to know the truth. There's 3 sayings in Jewish tradition. If I am not for myself, who will be for me? If I am only for myself, who am I? And if not now, when? The second one being the most important here. Maybe the second and the third ones being the most important here. Because I can't just sit here and advocate for things that are only for me. I need to advocate for other people as well. I'll talk more about that in a second. And again, if not now, when? The time to act is not in the future. The time to act is now, to protect body autonomy. Well, the time to act was back in 2016, when people refused to freaking vote. But,